Thank you, Rachel. That was a great report about a really sad case, and I want to talk a little bit more about it before we begin, and ultimately we will go live into that courtroom. Joining me via Skype is criminal defense attorney Gary Gerstenfield. Gary, it's great to have you back here on Law and Crime.
Always a pleasure, Jesse. Good to see you.
As we wait for the beginning of this case, what can you expect in the opening statements?
Well, the prosecutor is going to come on very strong. This is a very heart-wrenching case, of course, involving a 22-year-old little baby that was gunned down, and it's just a wrenching story. So, without question, the prosecutor's position is going to be to come on very strong and really grab at the heartstrings of the jury. The defense, their position is got to be, look, this is a case of whether or not there's enough evidence to convict. They're going to be looking at this from a point of view of, hey, can you prove this case beyond a reasonable doubt? So their approach is going to be follow the law and don't allow emotion to control what you want to do as a jury and what you're going to do in the verdict.
So let's talk about the law real quick. They are charged with attempted murder, discharging a firearm, but really the crux of it is murder in the second degree. Now, I know, I got to tell you, we all went to law school here, and even if you didn't, murder in the second degree is a little bit confusing. Everybody knows what first-degree murder is, but second degree, what are we talking about here? How could they be found guilty of second-degree murder in connection with the death of this young boy?
Well, first-degree murder is a very specific charge in most jurisdictions. It requires a premeditation with the intent to kill a specific individual, or at least intent to kill somebody that's somehow premeditated. Second-degree murder is something less than that, but clearly it's something where, you know, in the case of using a handgun, where murder is going to result, and there is an intent to use the gun, and it's intentional that you're going to, that by shooting the gun, it's going to result in somebody's death.
Yeah, I mean, we're going to have to wait and see. It's a really sad case because, as we talk about from what we know so far, it doesn't look like they intended to kill him. That was not what it was, but it was a drive-by shooting gone bad, although I don't know how those can go well. We'll have to learn a little bit more about it. It is a sad case, and we will cover it here. Gavel to gavel on Law and Crime. But before we begin with our live trials of the day, as always, every day we have the top crime stories here on Law and Crime. Let's play that for you right now. Anthony, thank you as always. Great reporting on those stories. You can go to lawandcrime.com to learn a little bit more about them. But before we do that, I want to talk a little bit more about that hit-and-run case. Mr. Morse facing some pretty serious charges, and he admitted that he did this on purpose. Want to bring back in criminal defense attorney Gary Gerstenfield. Gary, I'm confused. He has no relationship to the victims, but purposely did this?
You know, it's going to be a very strange case and very interesting to watch. He certainly hasn't made it easy for his defense team. You know, I often feel with these cases that, you know, how many contortions can you make a poor defense attorney go through as he tries to somehow, you know, weld his clients through a case where, you know, the evidence is so compelling. This will be a very interesting case to watch.
But reading this case, clearly there's something wrong here with this man. That's not an understatement, because he has said, hasn't he given evidence of saying he was compelled by the devil to do this? I hear that. I'm thinking maybe an insanity defense or something of that nature. Is that what you're hearing as well?
Well, that's be very interesting because, of course, if you're making an argument of insanity or not criminally responsible, you're trying to basically say that I committed the crime, so I don't deny my involvement in committing the crime, the physical act, but I lack the mental capacity to either A, stop myself from doing it, or B, I was unaware of what I was doing would actually cause somebody's death.
So if this is the statement that he purportedly said in a video, yeah, devil, this is all your fault because you descended to earth. Why am I not in a state of harmony right now? Because of her evil. And investigators are looking at disturbing content that he had posted on social media accounts. When you hear that statement, if you're representing him, is that a good sign of, maybe we might have something here in terms of insanity plea?
Well, it's a question of whether or not you can have him appropriately evaluated and you're able to get an expert who's going to be able to render an opinion saying that this person lacks the mental capacity to be criminally responsible.
And even if he admitted to purposely running them over, we've seen this before, and I'm very interested by this. even if a defendant makes statements in a police interview or to authorities, that's not necessarily the end-all be-all for his case, correct?
Absolutely. It's just among the things people say in an interview. It's certainly an admission. It certainly adds culpability by him saying that, he's acknowledging the physical act. The question is why he's doing it, and the motive behind it, and can his defense attorney find from those statements, along with a lot of other information, obviously, as to whether or not he can make an argument that the person lacks the capacity to have the mental mens rea to commit this specific act.
What a sad case, a alleged, track and field star destroying a family like that. Really, really sad case. We'll cover it more here on Law and Crime, but as always, go to lawandcrime.com to learn a little bit more about those stories and the top political, legal, entertainment stories of the day. Now, we want to switch gears right now and focus on one of the cases that I've mentioned at the top of the hour. We are in verdict watch in the Timothy Coggins case. Again, this young man who was killed back in 1983. It remained a cold case until now. Multiple people have been charged with his murder, including Frankie Gebhardt. That is the person the defendant. That's the case that we've been following this past week. And what have we seen? We've seen the prosecution introduce multiple witnesses, people who have come forward and said that at some point in the last 34 years, Frank Gebhardt admitted to killing Timothy Coggins, or was at least referencing or giving an indication that he was implicated in the murder of Timothy Coggins. Now, that's pretty strong evidence. However, there's not a really forensic evidence or eyewitness evidence pointing him towards this crime. Now, what I want to do as we wait for the verdict watch, as we wait for the jury to come back with a verdict, I want to play you the defense's closing from yesterday. This is Frank Gebhardt's attorney explaining what does the state really have against their client. And you be the judge. Take a look. That's the defense in the Frank Gebhardt case out of Georgia, the Timothy Coggins murder trial, casting doubt, or trying to cast doubt in the minds of the jury. Now, we have a live feed. You can see it right there into that courtroom, but that is not the only case that we have a live feed in as well. As you can also tell, we are live in that Florida courtroom. This is the case of Kwame Richardson and Henry Hayes, the two men who've been charged with the murder of that 22-month-old Aiden McClendon, who was gunned down really a tragic way during a alleged drive-by shooting. So we're going to be live in that courtroom in a little bit, but we want to maintain the focus right now on the Gebhardt case because we are in verdict watch. We're waiting for a verdict any moment. Could happen now, could happen later on in today, could happen tomorrow, but we're carefully monitoring it. But I want to talk a little bit more about what the defense just said. So I want to bring back on Gary Gerstenfield. Gary, when you're listening to the defense's closing argument, and first he said, look, the prosecution brought out all of these jailhouse informants. It's a get-out-of-jail-free card for them. They're testifying for the state because they have an incentive to. Is that a fair argument?
Oh, heck yes. It's the snitch business where you bring on the guys in jail and, oh, yeah, while I was in jail, Frank told me this and he told me that.
But what happens if they said, hey, listen, we weren't promised anything. They said, prosecution said, hey, if you testify and then you can come forward, maybe then we can have a conversation, but they never promised them anything beforehand. What do you think about that?
Well, let's just say, let's give a number to the value of a specific witness. So let's say a doctor or a member of the clergy or somebody that's highly respected, a scientist or somebody that's admired, comes to court and gives testimony. We'll give that a score of 10 because that's a really perfect witness. A jailhouse snitch, maybe a 1. So if that's the quantitative value of the evidence you don't have a very compelling case. And that's always the problem that the state has. I mean, jailhouse snitches, certainly, you have them, you use them, but you can't wrap your whole case around the hope that that's going to be what's going to, get you to the finish line, because I don't think it does. Playing
devil's advocate, though, if you have such a lack of evidence because it's been 34 years, so much of the evidence has been lost, and they say, look, this is all that we have. Sorry, jury, this is all that we have. But as I think it was interesting, the defense said that's not Frank Gebhardt's fault. That's just the serious. That's just what it is. I mean, I know people want justice here, but at the end of the day, Do you cut the prosecution some slack because it's been 34 years, so much evidence has been lost? There was a botched investigation, allegedly, back when this happened? Or do you say, sorry, prosecution, we're not cutting you any slack here?
Well, it's a mixed bag. I think the point that, for at least from the prosecutor's standpoint, is to say, look, it's not our fault that this evidence is so atrociously bad, if that's the argument they're making. We've lost evidence. We call that spoliation. We're relying on jailhouse snitches because we just don't have any other witnesses to rely on, and that's what we've got. And use this to find beyond a reasonable doubt to convict a man of a crime of murder, particularly where the crime is as heinous and just terrible as this is, a tragic death of a human being. It is absolutely atrocious. And of course, it brings us all back to the horrible memories of the murders the murder of James Byrd in Texas. I mean, it's basically the same type of event, and it's a wrenching issue. But the defense is making a good argument, saying, look, these are terrible facts. It's a terrible thing that happened, and we want to see justice, but justice requires that the evidence be just. And that's the problem they're trying to argue against the state in the case the state is trying to present.
We have a lot to cover with this case, including some more of the defense's closing argument, because it was really effective, in my opinion, about what the jury will be left with in terms of the prosecution's case. Ultimately, we'll have to see what the jury decides. We'll talk a little bit more about it in a minute, but before we do, I want to play you right now, our very own on Law and Crime, the Officer of the Week. Take a look. Welcome back, everybody. So we are in verdict watch in the Timothy Coggins murder trial. Will a jury convict Frank Gebhardt of the murder of this young man back in 1983? That's what we're waiting to see. Let's talk a little bit more about this with criminal defense attorney Gary Gerstenfield. Gary, we are playing the defense's closing argument. They're making the point that people's memories are getting better over these 34 years. They're not getting worse. Now, here's my question to you. The defense has been really keen at saying that so many of these witnesses are coming forward now, when they had the opportunity to come forward back in 1983 but didn't, are coming back now for some sort of gain. Many of them are in jail, and they might be able to get some leniency if they testify for the state. Here's the question, though. Are all of them lying? Can you have a situation where every witness is lying? If you had two witnesses, maybe one witness who says they heard Frank Gebhardt say that he did this, maybe I'd be like, okay. But to claim that every one of these witnesses who said that Frank Gebhardt confessed to them, if I'm sitting on the jury, am I supposed to believe that every one of them is not telling the truth?
Well, that's probably the best thing the state has going for it, the idea of the cumulative effect that all these people coming forward can't all possibly be lying. Maybe some are lying. Maybe there's a motive for some of these people to try to help the state out, to try to get a better deal for themselves and their own situation they're having. One of the challenges that I think the defense is doing a good job about bringing up is the idea of refreshing people's memories, the idea that, you sit down with the prosecutor or you sit down with their investigators, and now you have more information than you started out with, or maybe your memory is somehow enhanced. And the question is this honest testimony from individuals that are recalling an incident from 34 years ago, or is this simply people now that are parroting back what they were told by the prosecutor, particularly where they've got their own motivations, which is trying to get, as you pointed out, a more lenient sentence in their case. I think that's an excellent argument being made by the defense.
And this is a challenge on multiple levels, because we know that the prosecution has come forward and said that this is a racially motivated attack, a brutal attack. You have a white defendant and a black victim. Now, here's the interesting part about this, though. They talked about the testimony of Jesse Gates, who is somebody that knew Timothy Coggins and drove him to the People's Choice Club the last time that anybody ever saw him alive. He said that he saw 3 white men outside of the club, which he found very unusual because it was a predominantly African-American club. Then you heard Timothy Coggins' sister come forward and said she saw a large white man looking for Tim in the club. But there's no indication that that was Frank Gebhardt, and maybe no indication that was Bill Moore Sr., who's going to be tried for this crime later on. But there's no evidence that I've seen other than it's a white person, and Mr. Gebhardt is white and also was tall, apparently, and a stocky individual. So how much is there a danger of saying, hey, white person, it's Frank Gebhardt?
Well, I think that's a good argument. I mean, the problem is you're talking about an incident that happened 34 years ago, where the prosecution, for a variety of reasons, probably racially motivated as much as anything else, failed to do a real investigation, preserve good witness statements, and really categorize what evidence they actually had against, ultimately now against Frank Gebhardt. I think that this is a tough case for the prosecution at a number of different levels. And it'll be interesting to see what the jury ultimately does with this.
Frank Gebhardt was on tape using the N-word. That's tough for a jury to hear, even though they're supposed to be impartial. So the fact that he just used racial terms and was kind of wish-washy about the Timothy Coggins murder, how much is that going to hurt his case?
It hurts. I mean, clearly, when you show that somebody's a racist and you show that somebody is, what you're saying is this person is dismissive of another individual simply because of the color of their skin or their religion or whatever. And when you suggest that somebody's dismissive about another human being, it means that maybe that person would not feel at all reluctant to see something bad happen to them, or themselves maybe not feel bad about hurting them.
Well, listen, as we talk about the witness testimony, that's really a big issue in this case. I want to talk a little bit more about the evidence that was collected. So as we wait for the verdict in this case, we're keeping a very careful eye on that courtroom feed. As soon as we have an update, we'll make sure to go to it. We're also keeping a very careful eye on all the other trials that we're covering as well. This is the part of the defense's closing in the Timothy Coggins case where they talk about the collection of evidence and whether or not this actually says anything about their client. Take a look. That is the defense making a passion plea to the jury there and telling them why they should not convict their client, Mr. Gebhardt, Frankie Gebhardt, of the murder of Timothy Coggins back in 1983. So we have a live feed in that courtroom. You can see it on the top right-hand corner of your screen. But we are also live right there in that Florida courtroom for the new case that we're going to be covering, where two men have been charged with the murder of a 22-month-old baby boy during a drive-by shooting. It's a really sad case. We're going to cover it here. We are waiting for the opening statements, and that, again, is a great opportunity for the jury and for us as viewers to understand what has happened in this case and where they are planning to take this trial. So as soon as we're live in that courtroom, we're going to make sure to go to it. In the meantime, I want to recap a little bit what the defense was arguing in the Timothy Coggins case. So let me bring on Gary Gerstenfield. A couple points I want to make here, Gary. The first part is there is a difference. They said there's a difference between committing a murder and saying you committed the murder. But if you never committed it, why would you brag about it?
Well, I guess the argument is that you're bragging about committing something that you didn't do, like perhaps bragging about how you were a fighter pilot or that you fought in Vietnam or that you did something that you didn't do to try to make yourself look bigger and badder than you really are.
I do that all the time. So, okay, I understand. Please continue.
Look, sometimes you have tough facts and you're trying to deal with them. So he's trying to reconcile, if you want to believe that my client made these comments, hey, he's just bragging about something he didn't do. And by the way, look, I've got, you got a case here where there's just no real physical evidence. The evidence was actually at some point collected and then for whatever reason lost, thrown away.
But why? I have to stop. I have to ask you, how on earth, I don't care how long ago this was, how is this evidence lost? How is it not preserved? Unless, and correct me if I'm wrong, because no one cared, is the argument that they put forward is that no one cared about the murder of a young black man back in 1983 in rural South Georgia.
It is a heart-wrenching aspect of this case, which is that, perhaps the evidence would be able to prove beyond anybody's question as to who did it. And yeah, this willful, which is the only possible conclusion I think you can reasonably draw, that the evidence was just tossed. And I think you're absolutely right. I think there was just a total lack of commitment towards finding the perpetrator of this horrible crime.
Now, we have an update from the Gebhardt jury. Again, we are on verdict watch. We're waiting for them to come forward with a verdict. This is a question that they just asked, Gary. They said, who is Willard Sanders to Christopher Vaughn? Who did Vaughn say was with him when they found the body? The judge cannot, the answer to that was the judge cannot respond. The evidence in this case is closed. Again, Willard Sanders, Christopher Vaughn, two people came forward for the prosecution and said that, pointed the finger at Gebhardt and said that he was the one who did this. He confessed to them. What does that question from the jury make you think?
Well, number one, there's a question among the jury as to what witnesses actually said. That's important from the defense point of view, because what that means is there's conflict in the jury room in terms of who said what and what does that mean. And the judge is absolutely correct. Once the evidence is closed, you cannot allow the jury to come back and say, hey, give me more information. That's the whole point. You get the information during the trial, then you go and you deliberate. And a lot of times you get these questions where, gee, what did that witness say? Or, gee, what did that mean? Or what are these relationships with these people? Again, is there motivation to lie? Is there motivation, bias, things like that? These are good questions the jury's thinking. It's a good sign that this is a thinking jury. But, of course, the judge cannot answer those questions.
Right. It seems that they're specifically taking apart each one of the witnesses who came forward. As I said at the beginning of the program or earlier, that do you just say a blanket statement, we can't trust any of these witnesses, or do you say, let me take a step back and think about what each one said, what they have to gain, and what their relationship is to the defendant, to Timothy, and to each other? And that becomes the big question that they will be answering. I do want to let our viewers know, so again, on the bottom right-hand corner of your screen, you see that's a live feed into our new trial in Florida. Two men, Kwame Richardson and Henry Hayes, will be on trial for the murder of 22-month-old Aiden McClendon. We have a report about this case in case you're just joining us. This is a really tragic case out of Florida that we will be covering in any moment. Take a look. There seems to be that's going to be a big issue. We know that there are at least two witnesses won't be filmed or have audio during the courtroom proceedings. They are gang members, and one has already been beaten up in jail. The gang aspect of this case, how does that make it a different trial than anything we've seen before?
You know, it's interesting. I've been a criminal defense lawyer for 25 years, and I have to tell you, when you're representing, again, I'm the defense attorney, when you're representing a guy who's in a gang, you've got a tough case. If there's one, I mean, maybe sex offenders don't have, anybody who loves them. They don't have a constituency. But let me tell you something. People in gangs, people have this hatred. The gang represents so much evil that being associated with the gang is it's just like standing at a beach with a big wave coming right at you.
Gary, I think you said it best. It really does represent a lot of evil, especially when you have a dead 22-month-old baby boy. We have the opening statements beginning right now in that Florida courtroom, so let's go live. Welcome back, everybody. Let's break down what we just heard. I'm here with Gary Gerstenfield, criminal defense attorney. Gary, I know we have to let you go, but before we do, you heard it. You heard the prosecution's opening statement. What did you think?
I thought it was one of the best opening statements that I've heard in a long time. What she did was gave a very good overview, explained motive, she explained opportunity, the physical evidence, she went into the scientific evidence, she went into, and this is a good contrast, I think, because she talks about how these witnesses there are imperfect, and she explains, even though they're imperfect, you should still give them credibility. I thought she did a really good job. Was
there anything that you wanted to learn a little bit more, anything that needed a little bit of clarity?
You know, I'll tell you, the problem is once an opening statement gets too long, I think you start to lose the jury.
Yeah, you might be right. Gary, listen, we are going to have to sign off. We have to jump back in. The defense is beginning their opening statement. Thank you so much for joining us.
Absolutely. Good times. Take care.
Okay. Actually, Gary, I'll tell you what, we're waiting for the feed to start. So, again, I'm sorry that I had to cut you off there. What were you saying? You would have wanted a little bit more.
Well, in terms of how long an opening statement can be, I've heard it say that once you go more than about 20 minutes, you start to lose your jury. So you have to, you've got a lot of information you want to give. I thought she did a real good job by talking about how they had experts who were going to testify and how they had expert witnesses without actually going to their names and overwhelming the jury. I thought all that was very powerful.
Gary, thank you so much. We do now have the live feedback there. The defense is beginning their opening statement. Can't wait to have you back on to talk about this case and other cases.
Absolutely. Take care now.
Thank you. Okay, everybody, let's go live into that courtroom.